I'm so sorry, ma'am. I know you need this medicine, but it looks like it's not covered by your insurance.
Yeah, unfortunately, I had to deny that one.
Wait, who are you?
I'm your insurance company's pharmacy benefit manager. I get paid based on the price of a medicine, and I don't make as much money off this one.
No one should stand between you and your medicine. Visit phrma.org/middleman to learn more. Paid for by Pharma.
Hi there, and we are back for another emergency episode of Amicus. That's Slate's podcast about the courts, the law, the Supreme Court. I'm Dahlia Lithwick, and I'm here with Mark Joseph Stern. We try to cover the courts here at Slate. This episode is part of our Opinionpalooza series. We are making all of our weekly and bonus emergency episodes of Amicus available through the month of June to all of our listeners. We are trying to work really hard to create a new type of Supreme Court coverage. Get up to speed at slate.com/opinionpalooza. Help support our work when you become a subscriber to Slate. So here we are popping in to talk about a huge important case that came down on Thursday morning from the Supreme Court, Haaland versus Brackeen. That is the Indian Child Welfare Act case that threatened to massively undermine tribal sovereignty. We're going to talk for a minute about Smith versus United States, which might have been important when Jack Smith was deciding last week whether to file his indictment in U.S. v. Trump in Florida or D.C. So to do all this, welcome back, Mark Stern.
So happy to be here with some good news for a second week in a row. Like, did I accidentally take acid instead of Motrin? What is going on here?
It's so strange. Last week, I think I wrote that, you know, the voting rights case felt like, don't get too excited. It's the feeling of not getting punched in the mouth today. But like 2 weeks of not getting punched in the mouth, it starts to feel like a trend. And we're going to talk about it in a second, but this is another just resounding win. This is not a question. Let's start then with Brackeen. I think both you and I we're watching this pretty carefully because this could have been absolutely devastating for Native American tribal rights. And when the case was first heard, it certainly at least had the theoretical possibility, not just to undermine the constitutionality of the Indian Child Welfare Act. That's the 1978 sort of gold standard law seeking to keep Native American children with Native American families. It actually had the power, if the plaintiffs had gotten everything they wanted, to chip away at Native American tribal sovereignty in like a death by a million cuts. And I just want to play for a second Justice Gorsuch saying as much at oral argument.
This new rule would I think, take a huge bite out of Title 25 of the U.S. Code, which regulates the federal government's relationship with tribal members. There are health care provisions that Congress promises to Native Americans off reservation. That doesn't seem to fall in any of your buckets. Congress has permitted tribes to exercise power over environmental regulations that have indirect effects off reservation. That would seem to go too. We have laws that promise Native Americans access to sacred sites off reservation and religious liberties off reservation. That would seem to go. And I'm not even sure maybe the liquor sale, those old precedents, but maybe that's commerce, I don't know. But there'd be a lot that would be bitten out of Title 25. We'd be busy for the next many years striking things down.
So here we are, Mark. That didn't happen. Nominally, this case was a challenge to ICWA, the Indian Child Welfare Act. What were the facts of the underlying case? Maybe start with the challenge that was filed by Chad and Jennifer Brackeen and the other adoptive parents and a handful of states, but by the end of it, Texas against ICWA.
That's right. So Texas teamed up with several adoptive parents to challenge this law, ICWA, that was designed by Congress to redress this grievous historical wrong. Starting in the 19th century, Congress passed these programs that were designed to forcibly assimilate Native children into white culture. Essentially, Native children were kidnapped and abducted from their tribes, forced to these so-called boarding schools where they were barred from practicing any cultural traditions. If they disobeyed, they were beaten, sometimes to death. There was sexual abuse, rampant starvation. This continued into the 20th century with states taking over. States very frequently snatched Native children from their families and their tribes and tried to sort of shop them out to white families who would assimilate them into white culture. But Texas and these adoptive parents said, hey, this law that was designed to stop all of that, it's actually totally unconstitutional. And they had three main arguments that I'll go through, although they're kind of related. The first argument is that Congress just doesn't have this broad power to regulate Indian affairs. I'll use the term Indian because that's what's used in the law and in the decision. That Congress just has this very cramped authority to regulate maybe like trade with the tribes, but anything beyond that is exceeding Congress's power. The second argument, very similarly, is that this exceeds the 10th Amendment by infringing on areas of law traditionally practiced by the state, specifically family law. And the third argument was that this violated equal protection principles by discriminating on the basis of race. So they raised these arguments because of the specific way that ICWA functions. There were a lot of different ways Congress could address this, but Congress went after custody proceedings because that was where the action was happening. That was where state courts were taking a consistently biased view against Native families and Native children and trying to place these kids with white families as frequently as possible. So Congress, through this law, told state courts, look, first of all, whenever there is a proceeding involving a Native child, you have to notify the tribe in which this child is either enrolled or would be eligible for enrollment. And you have to let the tribe play a role in the case. And when you are deciding where the child will be placed, you have to have a preference for either a member of the child's extended family, a member of the tribe in which the child is enrolled or eligible, and then finally, if neither of those is possible, then placement in another tribe. Although, to be clear, that's probably never happened before, so we're really talking about extended family or community. And the law says we want these kids to stay with their communities. We do not want them to be farmed out and forcibly assimilated. And these families, together with the state of Texas, said, this is racist. This violates Congress's power, and we want it struck down. Why did they do that? So, first, yes, the parents claim that they have this deep, deep desire to be white saviors and transform these children into upstanding white American citizens. But what's really going on here is that Congress plays a very important role in protecting tribes from exploitation by both states and corporations, and especially exploitation of tribal land, much of which is rich with natural resources. The goal here was not just to knock down ICWA, but to knock down basically most of Title 25, which is the part of the federal code that regulates Indian affairs, and suddenly open the door to an extreme amount of exploitation of these tribes and their land by just stripping away the federal government's ability to step in and say, no, we have an obligation and a constitutional prerogative to protect them from this kind of malfeasance. That is why so many corporate lawyers and big law firms lined up on the side of Texas in this case. They were doing it because they saw money on the other side of it. And if they could pretty much obliterate Congress's historical authority to protect Native peoples, then they thought that they would get a whole lot of profit on the other side of this case by sort of declaring a free-for-all on Native communities and Native land. And all of that was at stake here.
Which is exactly what we just heard Justice Gorsuch saying in some sense. I just want to button down two strands that you just said that I think are important. One, the genesis of ICWA, the genesis of this concern for breaking up families, taking children away, often under pretexts, links up to the conversation we had last year with Dorothy Roberts and her whole book, Torn Apart, just about what it is to be sort of subject to the vagaries and the incredibly racially biased vagaries of removal and foster care and adoption and, the mere act of trying to parent when Indian, in some sense, which, is unmeetable in some circumstances, is very much the thing that ICWA was designed to remediate. The other thing I think is worth saying is that there is a vibe you've just described, which is the plaintiffs did one of those kind of everything but the kitchen sink. Mm-hmm. They were just going to throw everything and, whether it was of dubious provenance, whether it made no sense, whether they couldn't actually prove the thing they were alleging. There was a sense in this case, and you really feel it in Justice Barrett's majority opinion for the court. And this really reminds me of the conversation we had last week about the Alabama legislature in the voting rights context, just kind of YOLOing their way through this and saying, we're going to win, so we're just going to make every argument we can, and some of them are going to be bad. And I just want to say that by way of saying, when we talked about the Voting Rights Act case, the Section 2 case last week, I think I noted, either in print or in conversation with you, that it felt like it was John Roberts channeling Elena Kagan's dissent in Brnovich. Here, you read Amy Coney Barrett, Mark, and she's rejecting every single one of these kitchen sink arguments, sometimes pretty perfunctorily. And I just want to start by saying, she opens by quoting House testimony from 1978 when ICWA was being debated from tribal chief of the Mississippi Band of Choctaw Indians, explaining that ICWA was necessary because, quote, culturally, the chances of Indian survival are significantly reduced if our children, the only real means for the transmission of the tribal heritage, are to be raised in non-Indian homes and denied exposure to the ways of their people. I mean, it is so deeply solicitous for the kind of cultural, the vulnerability, the long, ugly history. She apparently gets it.
Yes, I think so, which is not actually a huge surprise because there was a 5-4 decision last year involving tribal sovereignty and state regulation in which she cast the 5th vote to join with Gorsuch to protect the tribes against state intrusion. But yes, this really affirms in pretty resounding rhetoric the sweeping power of Congress to step in and protect Native families and tribes from destruction. And because of that overall tone, I feel pretty confident that even though the court actually didn't answer every question on the merits, and we'll get to that in a second, that this looks a lot like a majority of the court saying, we are not going to destroy Congress's handiwork on the heels of centuries of egregious discrimination against these individuals. We are not going to step in and say, oh yeah, Congress spent so many decades using its power to try to hurt Native people. And now that it's using that power to try to help Native people, we're going to say, you can't do that. I mean, that would be a terrible look for the court. And I think, as you say, this opinion makes it clear from top to bottom, the majority gets it. The majority gets the purpose of this law. The majority sees that purpose as not just legitimate, but compelling. And so even though not every single question was shot down on the merits, it feels to me like it's a good bet that ICWA is going to survive future encounters with this court. And that is just a huge relief for anyone who cares even a little bit about the principle that tribes should be able to protect and safeguard and enjoy the sovereignty they're granted by the Constitution, and that Congress should be able to step in and help them with that task.
We are going to take a quick break.
I'm so sorry, ma'am. I know you need this medicine, but it looks like it's not covered by your insurance.
Yeah, unfortunately, I had to deny that one.
Wait, who are you?
I'm your insurance company's pharmacy benefit manager. I get paid based on the price of a medicine, and I don't make as much money off this one.
No one should stand between you and your medicine. Visit phrma.org/middleman to learn more. Paid for by Pharma.
Hey there, Amicus listeners. It's Mary Harris from over at Slate's daily news podcast, What Next? What Next is a show we make to help you grapple with this question. how do you keep paying attention to the news when it feels like the news is stuck? You know what the Republicans are going to be saying. You know what the Democrats are going to be saying in return. You probably even think you know how you're going to feel about all of it. My short daily podcast is here to help you make sense of things, even surprise you, from fleshing out new angles to uncovering stories that have largely gone unreported. When the news feels a little predictable, I'm here to help you answer what next. So subscribe wherever you're listening right now.
More now in this Opinionpalooza emergency episode of Amicus with Mark Joseph Stern. So let's get to the questions that are reserved, because I think this is the part where doesn't feel like the fullest of full victories. And clearly, while I think you and I agree that the Barrett opinion seems to render ICWA bulletproof, she is certainly reserving the equal protection questions, the non-delegation questions for another day. And that turns on standing, which, by the way, I think you called this. You flagged that there was a standing problem after oral argument. So can you just walk us through what the court did not decide in terms of particularly these big equal protection, non-delegation questions, and also the fact that Brett Kavanaugh seems certainly open to revisiting at least the equal protection part?
Yeah, I mean, the non-delegation piece of it, I just think we can set aside. It's dealt with very, very briefly, and it's largely of a piece with this other issue about congressional power. Like, I don't think that the justices are particularly interested in that. Let's talk about the equal protection issue, which is the real heart of this case for the parents who brought the suit, and the big kind of lingering question after this decision. So the parents had argued that this law discriminates against children and prospective parents on the basis of their racial identity, because, again, it requires state courts to favor placing a child with either a member of their extended family or a member of their tribe before placing them with a non-Indian family. And to be clear, like, if the court has good cause to not place them with a tribe or an extended family, like, the court can override these commands. If there are legitimate reasons why the child should not be placed in his or her community, like, the court can still override these commands. This is what is internationally recognized as the gold standard of how you balance the interests of preserving communities with the best interest of a child. And in fact, ICWA has formed the basis of a number of international laws and domestic laws that try to balance those interests in a way that's humane and lawful. And so the argument here was, again, that this was racist. The problem with that argument is that the Supreme Court has said for many, many years that Indian status is not a racial classification. It is a political classification. Whether you are enrolled in or eligible for enrollment in a tribe is a fundamentally political question. And that means that any law that classifies on the basis of Indian status is not subject to heightened scrutiny. It is subject to very relaxed rational basis review, which means it'll almost always survive. And I think there are a lot of reasons that that's correct. One that I'll just highlight is that it's basically like in the Constitution. So the Constitution itself classifies people on the basis of Indian status and treats Indian people as a kind of separate political sovereign that the American government can do business with, can engage in commerce with, can regulate, but must respect on certain fundamental grounds of sovereignty. And if Kavanaugh is right, and if the plaintiffs here are right, that any consideration or so-called preference for Indian status is inherently race-based, then those provisions of the Constitution are probably unconstitutional, which, like, logically cannot be. And also all of federal law that regulates native peoples and native lands is unconstitutional presumptively, because we have thousands and thousands and thousands of laws and regulations that classify on this basis, again, because that's what we've been doing since 1789. And so, Kavanaugh is the only one of the majority, and it's a 7-justice majority. Kavanaugh is the only one who says, I'm really worried about these equal protection issues. He says they are serious. I think it is notable that nobody else joins him, specifically including Chief Justice John Roberts. I think if and when this case does ultimately come back to the court, that there are probably, or I would say almost certainly at least 5 votes to reject this equal protection argument. But in this particular case, the court didn't deal with it. Why? Because, Texas raised this argument, first of all, and states cannot raise equal protection arguments. Equal protection applies to people, not states. And Barrett has this kind of snippy line where she says, Texas raises creative arguments why this might not be so, but Texas is very much wrong. And then the plaintiffs did not sue the right parties for an equal protection claim. So they filed suit against the Secretary of the Interior. But ICWA is not enforced by federal officials. It's enforced in state courts, right? And so even if the court ruled in favor of the plaintiffs and issued an injunction against the Secretary of the Interior, it would not affect the functioning of ICWA. And that was something that I had been sort of screaming about from like the early stages of this case, something that the liberal judges at the Fifth Circuit had been screaming about. And I feel very gratified to see it vindicated because otherwise this just would have opened the door to a lot of very kooky equal protection suits, either by states or by individuals who sued the wrong person. And again, the fact that 7 justices were willing to say, we're not going this far, it seems like a pretty good omen that if and when somebody does sue the right party or figures out how to establish standing here, that the court's not going to do an about face and say, oh yeah, last term we, strongly upheld this entire law, but now we're dismantling the entire thing because we've passed the standing threshold and we can get to the equal protection issue. Doesn't seem like a likely outcome for me.
Yeah, I just want to highlight the ways in which, you and I keep having this conversation where the court is like, don't be sloppy. Don't lie to us.
Yeah.
Don't bring bad arguments. We're not carrying your water like for a big swing unless you take some kind of principled big swing. Set aside Dobbs for a minute. That was an unprincipled big swing, badly justified. But okay. It is so fascinating to read in Justice Barrett's opinion where she is essentially saying, I just want to read from this. It's so fun. We recognize that our case law puts petitioners in a difficult spot. We've often sustained Indian legislation without specifying the source of Congress's power. We have insisted that Congress's power has limits without saying what they are. Yet petitioners' strategy for dealing with the confusion is not to offer a theory for rationalizing this body of law that would at least give us something to work with. Instead, they frame their arguments as if the slate were clean. More than 2 centuries in, it is anything but. If there are arguments that ICWA exceeds Congress's authority as our precedent stands today, petitioners do not make them. We therefore decline to disturb the Fifth Circuit's conclusion that ICWA is consistent with Article 1. It just feels like she's saying, please, 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 please do not treat us like you're dumb lackeys. If you're going to do something radical, do it well.
And that's Roberts and Milligan last week. That is
Exactly.
Roberts in the Voting Rights Act case. As you said before, that is the court's less wacky members saying, do not throw this outrageously bad lawyering at us. Do not assume that you have us in your pocket. And do not ask us to rewrite the entire book every single time you're coming to us. Like, we are offended by this particular approach to litigation and we want it to stop. I mean, I guess I'll just say, I think it's interesting. This case was spearheaded by Ken Paxton, the Texas Attorney General, who is currently impeached and under federal investigation for corruption. I'm not going to try to draw a direct line between those two things, but it is not surprising that a case masterminded by Paxton would wind up crashing against the hands of people like Amy Coney Barrett and John Roberts. You can't see me because this is audio, but I'm holding both of my hands out in front of my face saying, stop, do not bring this to us. This is stupid. We are smart people. We are real judges. Stop treating us like we are all Sam Alito, because I promise we are not all Sam Alito.
So that's where I want to land up on Brackeen, which is last year we kind of were Sam Alito. This was a much more consistent supermajority, really, as I said in Dobbs, not much caring what the vehicle was, just getting it done. And we are seeing, I think, and it's early days and there's still 20 cases left to come down in the coming weeks, but something seems to have shifted. And those 333 stories that were told, the first term when Justice Barrett came on, those stories seem now to be not credible, not a 333 court, not a moderate centrist block of Barrett, Kavanaugh, and the chief, but something feels like it's shifting. And I say that partly because of the sniping There's some real meow happening between the conservative justices. We haven't talked about the dissents, and maybe we can in a second, but there seems to be something shifting. And I just want to throw out a couple of theories that are in the ether. Tell me what you think. One has something to do with the presence of one Justice Ketanji Brown Jackson, who, as we may recall, both with respect to last week's voting rights case and now this one, has been taking the majority to school on the original intent and meaning of the 14th Amendment. And then it's awfully hard to look her in the eye and say the 14th Amendment means whatever we think it means when she is telling you precisely what it means. That's one theory. There's another theory, which is that Justices Alito and Thomas, for all sorts of reasons, are making it awfully hard to side with them. There's another theory which suggests that the court is in the face of massive public attention and, in some cases, fury and dissatisfaction beginning to blink. Do you have thoughts on any of this? And you can just say, Dahlia, too soon. And you can also say, Dahlia, it's all because we did a Slate Live show warning that this was coming. What do you think?
I think you could find support for each of those theories in this opinion, and I'll take you through them to show you how. So first, on the originalist point, this opinion is a rare good example of honest originalism, and that's really important because there has been a ton of scholarship on this issue over the last few decades, and some of it has been exposed as basically fraudulent. And Barrett explains this really well. There is a huge ample mountain of evidence that shows that when the framers were drafting the Constitution, just to reiterate this, that they wanted the power over Indian affairs to be sweeping and plenary, as Justice Barrett says. And that, in fact, when describing what counted as commerce or intercourse with the tribes, which is the terms that were used at the time, the framers and their contemporaries actually included adoption of Indian children. So that was fundamentally part of how the framers viewed congressional authority over and within Indian affairs. I want to commend Barrett because this draws on persuasive and contemporary scholarship and reasoning that has been all too absent from much of the court's Indian jurisprudence. And unfortunately, Justice Clarence Thomas once again relies on the work of Robert Nadelson, who wrote this article about how actually Congress has no power to do any of this. And that is just untrue. And I think Gorsuch does a good job debunking it. And Barrett really steps in and says, I'm going to go the honest route. And that is what Ketanji Brown Jackson was doing in the Voting Rights Act case from the bench. It is what she was doing in the affirmative action case on the bench. And even though we're not specifically talking about 14th Amendment, we are broadly speaking about issues involving race and political identity and congressional power. And I just felt like this was a moment where a very clear majority was eager to have bulletproof work and not willing to sign on to the slipshod garbage that is so common in Clarence Thomas's own opinions, where he'll just latch on to a fully debunked piece by some guy he likes because it happens to align with his view. Okay, that leads me right into point number 2. Alito and Thomas are bad at this. They are not persuasive and they don't know how to be persuasive. Just to reiterate, Clarence Thomas roots his dissent in scholarship that is fake, that has been comprehensively and meticulously debunked and refuted by Professor Gregory Oblowski, that misquotes, misattributes, or omits key pieces of information that actually refute his thesis. If you're trying to get Professor Barrett's vote, you do not rely on debunked scholarship. Sam Alito, for his part, takes the white savior view. His opinion is basically ode to the white savior. He says, oh, these poor children, what they really need is to be rescued by these loving non-Indian couples. How could we tear them away from the loving arms of these white people and send them back to their terrible Indian communities where they're not going to have as good opportunities in life? And that also seems very unpersuasive to a majority. It is, in fact, not rooted in any kind of constitutional principle. And so I think like the two of them just sniping from the sidelines, they are not doing anything to bring these justices that are a little bit more toward the center onto their side, and they blew it. Argument number 3, which is the pressure, right, that the court could be feeling and potential delegitimization and resulting lack of power. You know, I think this is one case where even just subconsciously, the justices must have known if we strike down this law, the headlines will be atrocious. This is a case involving a wretched history of abuse and discrimination. And all we have to do is nothing. All we have to do is step aside and let Congress's handiwork play out in the lower courts and in the states. And it doesn't take a lot to do that. And so while I can't attribute the majority opinion to any kind of direct concern about legitimacy or public backlash.
Or Slate's live show? You can't.
Or Slate's live show.
Okay.
I mean, that one's on the fence. I think maybe there's a direct line there. But I do think that this is a situation where the majority knows it can make itself look good by doing very little work and exercising a little bit of judicial restraint. And in these times, that's an opportunity to leap at.
Amen. Preach. Let's take a quick break.
Hi there, it's David Plotz, co-host of Slate's Political Gabfest podcast. And I am really excited to announce that we're doing a live show on Wednesday, June 28th. Please join me, Emily Bazelon, and John Dickerson at 6th and I in Washington, D.C. for an incredible night of political discussion, debate, and fun. Slate Plus members, you get an exclusive discount. So if you're not a Slate Plus member, this is a great time to join. Go to slate.com/GabFestLive right now to get your tickets. They are first come, first served. Again, that's slate.com/GabFestLive for more information and to buy your tickets for our June 28th live show in Washington, D.C. at 6th and I. We'll be streaming too, so if you can't make it in person that night, fear not. You can join our virtual gathering instead. Slate.com/GabFestLive.
Very last thing, quickety quick, the other case that came down today, and let's note there's still a lot to come in the next weeks, is a case that had to do with venue. What happens when the government gets its venue decision wrong? And Smith, which turns out to be a unanimous opinion by Justice Alito, had to have affected the other Smith. Let's call him special counsel. Does this Smith decision today tell us anything at all going forward? Is it the kind of thing where it was large in our minds last week when we talked about venue and why this case was filed in Florida and not D.C.? Anything to note about this decision as it comes down today?
Well, let's just apply real-world facts to it. Let's imagine that Jack Smith had brought this indictment against Donald Trump for the classified documents and obstruction in D.C., and he had gone through a whole trial and he had secured a guilty verdict and a sentence. And then a higher court said, actually, this was the wrong venue to bring the case. You should have brought it where the documents were, where all the action happened in South Florida. You shouldn't have brought it in D.C., so venue was incorrect. The question is, could Special Prosecutor Jack Smith then bring the same case in South Florida where venue is proper, or would bringing that case violate double jeopardy? And the answer is no. It does not violate double jeopardy for the case to be brought in another venue where it is proper when it was first tried in a venue where it's improper. This is actually like a kind of important decision that I'm surprised was only handed down in 2023. And I only wish it had been handed down in May instead of June, because I do think this loomed in Jack Smith's mind when he was considering where to bring these charges. And now we know that if he had brought them in DC and that had ultimately been deemed the wrong venue, he could have just brought them all over again in South Florida. Instead, he went straight to Florida and ended up drawing Eileen Cannon as his judge. So
Eileen Cannon.
Make of that what you will.
Yeah. Well, it just means that, unfortunately, reading the minds of the Supreme Court is a fool's errand, and yet it is what we are paid to do. So, Mark Joseph Stern, so good to have you back. Decisions come on Friday. There will be more, and then more after that. And you're awesome.
Oh, Dolly, you can't leave me like that with a compliment for me to just pocket and walk away. Dahlia,
I got nothing.
You make me
You're
sane. Awesome. You keep me alive in these dark times. And we have to sit on a beach and drink margaritas in July. We have to, because otherwise I'm not going to get through these next few weeks.
I think you and me and Justice Gorsuch and Justice Barrett and Justice Kavanaugh,
our new best friends,
and the Chief Justice, our new best friends, are going to be drinking mojitos very soon at a beach near you.
I'll teach them the margarita song.
Thank you, Mark.
Thanks, Dahlia.
And that is a wrap for this episode of Amicus. Thank you so much for listening, and thank you so very much for your letters and your questions. You can always keep in touch at amicus@slate.com, or you can find us at facebook.com/Amicus Podcast. Today's show was produced by Sarah Birmingham. Alicia Montgomery is Vice President of Audio at Slate, and Ben Richmond is our Senior Director of Operations. We'll be back with another episode of Amicus on Saturday morning. Until then, take good care.